All right, let's go ahead and get started, even though people are trickling back in. That always takes a while, but as a reward for those of you who are here and sitting down and quiet on time, we'll go ahead and start. My name is Phil Malone. I'm a professor here on the faculty at Stanford, and I run a brand new clinic this year, the Jules Gard Intellectual Property and Innovation Clinic, where we think about a variety of issues related to innovation, including innovation in the delivery of legal services and in legal technology. And I have to say, given my background, I'm thrilled that we've got a panel on the program today that's focused on and devoted to the public interest. That's the part of all of this legal innovation that is sort of most dear to my heart and to what I've done, and in some ways one of the most important ones. When we talk about legal technology or legal innovation in the public interest, we're normally talking about access to justice. We're talking about access to the courts, access to the system for people who otherwise wouldn't have it. Often that means unrepresented people, people of low income, low means, for whom a lawyer is just not an option. It's just not going to happen. Ron, when he talks, will give you some specific numbers, but the figures are pretty shocking. In a lot of courts around the country, the percentage of litigants who appear in court to defend their basic, really important rights, things about, things very fundamental to their lives, their family, their homes, their property, their immigration status, very high percentages of those people face the system unrepresented. And it's a huge problem, and it's one that's getting worse as court budgets are cut, as legal aid budgets are strained, as the general economic conditions push more people to need help. So that's a big part of what we're talking about. We're also talking to some extent about help for people who are underrepresented, people of limited means, but some means, who end up facing many of these same problems because they really can't afford or think they can't afford the full range of legal help that they need. So we'll be talking a little bit about both of those things today, and focusing on sort of what are some of the broader societal goals, really the big public interest goals that technology and legal innovation can further. We're really lucky to have a panel of two pioneers in this space, two people with really remarkable backgrounds in this space to help us sort through some of this and to give you a sense of both what's going on, what's coming, and maybe what it all means in the context of the other things you've been talking about today. So first up will be Ron Staudt. Ron's a professor of law at Chicago Kent and has truly been doing technology and access to justice, I don't want to say longer than anyone else, Ron, but probably as long as anyone, a very, very long time. Some of the things you've heard about already, for a young guy, that's very impressive. I started in your teens. But some of the things you've heard about already, and you will see in Ron's presentation, for example, A to J author, document automation software, and so on, Ron created. Ron and his team at Chicago Kent really pioneered that, pioneered the use of it and the multiple generations, and you'll hear about some of the difference that those kinds of things have made. Ron is also connected to pretty much every access to justice, innovation, discussion, group, whatever that's out there, ranging from the Legal Services Corporation Technology Summit a couple of years ago to a whole bunch of other committees and other work, as well as the technology clinics bit that Mark Lauritsen just talked about, and I think Ron will tell you a little bit more about. So somebody who truly knows this area, all of its nooks and crannies, and all of the things that are going on. Second panelist, Stephanie Kimbro, is also a real pioneer. Stephanie, among other things, really pioneered the field of virtual legal practice. I think for quite a while was literally the only person with a fully virtual legal office and legal practice. And from that has really expanded into thinking about innovating the way we provide legal services more generally and using the kinds of technology she used in her virtual practice, but also much more broadly into a whole host of other legal services and access issues. Stephanie's written not one, not two, not three, but 4 books about this whole area. I won't read them off for you, but they're in her bio, and they're all great. They're all really sort of very forward-looking, cross-cutting thinking about what we ought to be doing and how these new technologies let us do what we do. And I'm thrilled to say that Stephanie's going to be joining us here at Stanford in the Center on the Legal Profession starting this summer for a year to help really sort of pull together a lot of these threads and I think push a lot of what we do forward. So terrific people to talk about this. We're going to start with Ron, who will, I think, try to give you an overview and a lay of the land for exactly what we're talking about here. And Stephanie will give you a sense of some of the pieces of this that she's up to now and some things that are happening. We were supposed to have one other panelist today, Margaret Hagan, who's a recent alum of this law school, now at the design school, doing some really exciting work using design principles for legal innovation. She unfortunately has a schedule conflict, so I may show you a handful of her slides after Stephanie is up and try to channel very briefly a bit of what she would say, just so we have that in the mix. But then we really want to be pretty conversational, I think, about some of the big picture lessons and the broad takeaways that come out of the presentations. And we want to make sure we leave plenty of time for you all to engage in that conversation too. So with that, I'll turn it over to Ron.
Thanks, Phil. Well, I'm really delighted to be here, and there are pioneers in the room. Anne, amazing pioneer in AI and law, started right here, wrote one of the first PhD theses in AI and law. She was then in competition with Susskind, and he went over to the dark side and became like a market or a brand of one, you know. And Anne stayed true to her AI roots. And then Richard and Will and Mark, we've done so many things together. It's nice to see you all here and be with you today. Some of the stuff that I'm going to talk about came out of work that all of us did together. And it's nice to be here with all of you. And the nicest thing about it is I sometimes refer to myself as a technology optimism recidivist. And you can do that here, right? This is the place to do that because you're all like technology optimists. And I've been doing technology change agent kinds of projects literally since 1978, and almost all of them failed. Almost all of them failed. And around here they say, hey, that's great. You learn from failure and you go on. Hey, you know, how much money did you burn through when you failed? You know, I don't know. So what I want to talk to you about today is first sort of a shameful crisis, then some technology successes over the past 15 years that have been building to address some of these issues. And then at the end, sort of challenge you to think about, is there something bigger here? Is there a grand convergence that can take all this entrepreneurial fervor, all this market-driven enthusiasm, all these people saying, you know, I'm making $1.5 million a year and I just can't get out. Break my heart. I mean, come on. Take some of that fervor, right, and see if there's a convergence that can begin to solve some of these problems that Janelle showed us in her beautiful slides. So what I'm going to talk about is the thing that was on the far left of her slides where she said legal aid or legal services handled sort of. And this slide shows that it really isn't handled sort of. Like 80% of the legal needs of the poor and every legal survey of the legal needs of the poor come up as unmet. Sometimes it's 83, sometimes it's 79. All the studies show 80% are unmet. And so what does that translate into? So the Legal Services Corporation spends about $350 million. It's been higher than that, lower than that, but around $350, $360 million a year in supporting legal aid lawyers across the country based on population of poor people. Right? And 1 million people every year are helped by those lawyers in legal aid offices across the country. Paid for in part by that $350 million, along with some of that nasty IOLTA money that's just sitting there doing nothing. By the way, that money belongs to the clients. Did you know that? He can't have that money. Anyway. It's trust funds. Hello? All right, so in addition, 1 million people knock on those doors and are turned away every year. And probably another 3 million people never think about knocking on the door, never figure out they ought to go there. It's a lot of people. A lot of problems. And then and Janelle talked about the 75, 70% in the middle section. And we have some brewing ideas here, some crazy notions, some wild enthusiasm, and some entrepreneurial fervor. Now let's see if we can match them up a little bit. In addition, there's been this increase in pro se, and that's a phenomenon that's turns out mostly interesting to the judicial system. Judges get excited about that. So, successes. There are some successes. So 15 years ago, with a special little extra fund, started out about 4.3 million. I think over the 15 years, the total has been about 45 million. So sometimes it's 2, sometimes it's 3. The Legal Services Corporation, by statute, set aside this fund and said, no, you cannot hire another staff attorney, delegate agencies, although that would make easy sense. I mean, if you're a legal aid society director and you have this massive need coming at you, you just can't go wrong hiring another lawyer, right? But you might go wrong if you went off and spent some money on a technology project that, like most of mine, failed, right? And so you don't do it. You're risk averse in that way. This fund, this initiative, addressed that problem and set up a new kind of market, right? A market in ideas, a market in new initiatives, right? You couldn't just get the money by saying, I'm going to serve some more people. You had to have a way to use technology to dent that huge demand that we started with. And success has happened by consistent delivery of that incentive, attracting initiatives and changes and ideas. And so what are they? First of all, every state has an authentic single portal for legal information and literally a platform for delivery of legal services electronically to low-income people in that state. Every state has a single one. Most of them are on the same platform. A lot of them are driven on a service provider called Pro Bono Net, but there are some others. That's extraordinary, and that was forced by saying, we'll give you $30,000 if you do one, we'll give you $30,000 if you do one, and eventually they got it done. Second, the Legal Services Corporation, actually with a series of meetings that Mark Lauritsen led at Davis Polk in New York 15 years ago, interviewed all the people that had document assembly software to sell to lawyers and said, we want to standardize on a single document assembly product for all the legal aid lawyers in the country because Susskind says it's disruptive in a very positive way for our population. We want to disrupt, right? We got all these people that aren't getting anything. We can get in there and get them something with a lower per unit cost. That's wonderful. So out of that came a concentration on hot docs and a decision both to set up a national server so that every legal aid organization in the country and all those 50 statewide portals could then store and serve document assembly templates from a single national server, and a devotion of resources to train people to build those templates and those document assembly tools and so on. And third, A to J Author, which is the product that I've been involved with. Sarah's here from Cali. John Mayer has been my partner in so many things over the years, many of the failures John was involved with. And I blame him. Sarah, you can tell him, tweet that to him right now. But this one has been a great success. So I'll tell you a little bit more about it in a minute. But the numbers speak for themselves in terms of success, right? So a lot of times people come up here and talk at reInvent and they talk at Codex and they say, I'm going to change the world of law. Look, I got this great idea. We changed the world of low-income delivery because we had some great ideas and a lot of consistent effort from people like Mark and others. So there are now 3,000 hot docs templates on that national server and 1,000 A to J guided interviews. Last year and the previous 5 years total, 2 million times people went to the A to J guided interview templates on that and tried to prepare their own form or got some advice or made some difference in their lives. This year, another 600,000 will do it, 220,000 in the first quarter already. All right, what does the portal look like? Well, this is the Illinois portal. All right, so if almost all of the throughput to this portal comes from Google. People go to Google and they end up deep linking into the portal to a place where there's an answer, right? So, it's sort of a natural way for the world to find things. But this is what we used to call a guide me. It has different kinds of content, including forms and letters, and these are some forms and letters. That's a PDF form. These are A to J forms, and we'll show you a little bit of that in a minute. This is the portal, Law Help Interactive, which Mark Lauritsen almost single-handedly created and managed over a period of years, most of it with volunteer effort, actually. It's the place where these 3,000 templates, hot docs templates, and 1,000 A to J guided interviews are stored and served up to those 2,500,000 people. This is what A to J author looks like. So it's a graphical interface, a software tool to build graphical interfaces. What's the point? Why do we need it? Well, we did a design and law study 15 years ago. We took design students, law students, National Center for State Courts people, went to 5 different courts, filed judges, and self-represented people around for 2 weeks, took notes, took pictures, interviewed them, and so on. And it turns out they had a lot of trouble filling out forms. It turns out that it's difficult for them to deal with the complexity of hot docs, which is at the bottom, right? That they needed more hand-holding and more instruction and more support as they went through the process of preparing things on their own. And so that's what A to J author does. It sits in front of hot docs and gathers up into a file that hot docs can consume, an ANS file, all the data and all the information, all the choices necessary to drive a template, produce a document, or produce a form. And so the thing on the left is the graphical environment in which authors build templates. It's pretty soft. We say if you can do Excel and Word, we can teach you how to do this in a week or so, maybe 2 weeks at the most. The thing on the right is what comes out of the viewer when that guided interview runs for a low-income person or self-represented person. All kinds of just-in-time learning is built into this, and the design team was instrumental in helping us understand this. You just can't teach people stuff before they need it, right? What's your zip code? Well, you don't tell them that 3 weeks ago and then give them the zip code. Right when they have to fill it in, you say, here, click this button and it'll help you find your zip code. And so many other things. This software allows you to run movies, show pictures, pop up definitions, take you to other websites. All the possibilities of instruction and learning and guidance are available in the software. And we've been using it for a lot of different things. The document assembly front end is its design purpose, but it turns out it's a great way to do sort of triage and online intake, right? So you can go to a website in anywhere in the world, actually, and do an online intake interview for the western half of Ohio, out of the legal aid out of Toledo, done by Ed Marks. And you can figure out whether you're over income or not, or whether they're taking the kind of case that you have, and get yourself in line for an interview, never having to go there, never having to drive, never having to bother an intake worker, right? Sounds like something that would happen in Silicon Valley, doesn't it, right? Like sort of offloading some of the work of the business, offloading some of the enterprise to the customer in order to improve the efficiency. Benefits, eligibility screens, calculators, triage, e-filing. The Eastern District of Missouri has a bunch of these that it built and maintains for preparing civil rights complaints in federal district court there and so on. This is the, this is the VC people here. This is like a great hockey stick, man. Except the smart ones would say, what's happening here, man? Come on, there we go. What's going on right there? And for you over here, that's right there. We're forcing this hockey stick onto the curve, right? It's flattening out. We think there's 2 reasons. Reason number 1 is that the number of people who can build these templates for low-income people is limited, right? There are about 30 legal aid folk around the country who have learned and developed skills. They're on a listserv. We talk to them, we train them, we do all kinds of stuff with them all the time. But it's sort of leveled out at that. Mark's 30 about right? Maybe 40? Sound right? All right, so we think that problem can be addressed by some of the educational initiatives that Mark talked about with Apps for Justice, that we can teach law students how to build these apps and develop a whole range of learning, incredible skill sets, and at the same time begin to solve this problem. The second problem is that our software built 8-9 years ago is a Flash-based product, right? And those of you who are technical in the room know the limitations of that. Any minute, that was a good decision at the time, man. Don't laugh at me. Come on, 2.5 million, that's good, right? So you're laughing, I can see you're laughing. So we solving that problem, right? We came out with a beta in November, and the rollout of something that's more than beta any minute. That will be a complete web-based, cloud-based experience. You can do the authoring on the cloud. You can do the consuming on the cloud. So it can be done in like anything, any of these things, including an IBM XT. No, I won't be able to do that. We just thought, will you recognize it if we put it up there? All right. And with some help from that fund, we have the group of law schools that Mark identified, 6 or 7 law schools that have been building courses to put this kind of learning into the curriculum. And one of the answers to some of the questions that went before is you can fit this into all kinds of courses, right? We think it's a clinical initiative because clinicians care about justice and skills, but clinicians, it turns out in the United States, despite the fact that they were revolutionary 30 years ago, are getting pretty conservative, and they just want to keep doing the stuff they've been doing forever. And they're not very technical, and it's really sort of hard to break into them, although we have a bunch of them. We think it's interesting to note that one of our leading people is Judith Wegner, 55, 60-year-old former dean at the University of North Carolina, member of the Carnegie Commission, who does a professionalism course where students go off and shadow lawyers and so on. And then she takes 4 weeks and has them do a legal aid project with the North Carolina legal aid folks. These are the schools that we're working with now. We're going to do 6 new schools coming up. Let me tell you about what I think is a challenge for you going forward, tying in this entrepreneurial world that we're in now and this set of successes. I'm going to say in a minute or two a word about the summit, a little bit about something called the Pro Bono Initiative, and I'll go fast, Phil.
It's okay, we get that.
Okay. And a series of ABA initiatives. It's a nasty place, that ABA. I don't know. Can I say ABA in here? ABA. It's trying to do some good shit here, people. White House is involved, courts, law schools, state bar associations, and so on. So what's this idea? What's this Grand Convergence? All right, so this is Jim Sandman, a former managing partner of a big law firm in Washington, D.C. He became the president of the Legal Services Corporation. He commissioned this study, this summit. I think, Phil, you were involved in that, and Mark, and Richard, and Will, more people here. So we went off, and we studied, and we thought, and we came up with, among other things, the most amazing mission I've ever heard out of legal services in this country, right? Forever since Nixon, so Nixon signed the Legal Services Corporation bill. He's climbing onto the helicopter saying, I'm not a crook, right? And that was when the Legal Services Corporation bill was signed. It's true. It's the last bill he signed. And ever since then, what legal aid directors have been forced to do is figure out what cases they're not going to take. What cases they're going to turn away. How are we going to do case management? What are these lawyers, how can we keep these lawyers from burning out? How can we make the most impact on the poverty that's affecting our community, so on and so forth. This guy got up in this report and has been going around the country saying he's going to deliver through technology some form of assistance to everyone with a significant legal problem and not turn people away with nothing. That, my friends, is absolutely revolutionary in this little market. How's he going to do that? Well, some of the things that the group put together. So we're going to have a unified legal portal. I already told you they got a long run at that already, right? They have a unified legal portal out there. Sophisticated document assembly. We got a lot of that already. We have 3,000 hot docs templates up. Mobile technologies. I showed you A to J authors going to phones and mobile technology. Do it anywhere. Business process analysis and project management and project planning, and expert systems to do triage to help people get to the right place at the right time and make the right choices and allocate these resources in an effective way. There's another thing that sort of went on. I think the second best dean in the country, Martha Minow, who's the dean at Harvard. Now I'll leave you guessing who's the best dean. Who knows? Could be here. Oh, maybe not. She led this pro bono task force and was so successful in sort of energizing the country about tapping pro bono resources to solve legal aid need, that Republican congressmen added $2.5 million in an incentive fund this year to the corporation's budget. This is Washington, folks. So $2.5 million to try to tap into pro bono resources of private lawyers to help solve this need problem. And one of the things they're supposed to be doing, competitive challenge grants, one-stop shops, and statewide pro bono platforms. Starting to come together to me, right? So here's what I think we have. I think we have the world of legal need. And not only the people in that far left-hand blue thing that says legal aid, but probably well up into the 75% group, right? Coming to the web to find information, WebMD-like, going to Google saying, you know, I got a divorce coming up. Do I get the kids? How much do I have to, whatever it is, right? And they're looking around on Google. And if we do this one-shop stop, this portal right, the first place that they'll get to is a statewide website that has content, that has triage routines, and has referral options. And one of the things that they will be going to, well, I don't know. So they could go to courts, legal aid staff lawyers. They could go to law schools and the law school incubators that Will is gathering up, 25 law schools that have incubators, recent graduates who are trying to build practices. They could go to pro bono lawyers and self-help using A to J author and smart documents and so on. And all of this could be shared. So what's the potential that really makes me excited about this is the following. We heard a little bit of that in this previous panel. The potential is that it's possible that this process, if we put all this together in this grand scheme, could produce, in addition to good information and advice and direction and referrals and so on, a massive lead stream. A lead stream that's worth a lot of money, right? A lot of money. It's where Clio lives and Rocket Lawyer lives. It's where these Avo lives. All these people are living. The lead stream, they're going to sell leads to lawyers, right? Why not put that all together so that that lead stream, in addition to supporting incubators and new lawyers and helping get people some help that they need in unbundled legal services and so on, also throws off some money to maintain that statewide website environment and to help make a bigger dent into the low-income need that we're only scratching at this point.
So exciting, provocative, lots of stuff in there that hopefully we'll have time to come back and tease out a little bit. But let's keep elaborating on that and make the picture a little more complex and continue on with Stephanie, and then we'll go from there.
Okay, thank you. So Ron talked a bit about some of the tools that will be helping consumers, people with legal needs. And what I want to do is talk about how to engage the consumers, the public themselves. So we have and we build all these great tools, but how are we really having that conversation with the people who need the help and assistance? So when I'm thinking about the future of access to justice and to the law and legal education, I'm looking at it from both a perspective of engaging in a conversation with the public around the law, but also in terms of preventive law. How can we educate these consumers who may not even know they have a legal need to go on and look for a certain keyword on Google to get to that resource? So I want to take a step back and look at how do we even educate the public to know where to go to get engaged in some of these awesome tools that we're using and creating. Go to my slides. So one of the things that I want to talk about are games and gamification, which have been in the news a lot with other industries, gamification of business practices, but there are also games being created for social good. And why games for access? This is something I'm going to be exploring in the next year as a fellow here at Stanford. Ron mentioned that the LSC had a tech summit, and one of the things that came out of that report, they even mentioned gamification in games, was that a large number of these self-help resources are mobile. So a lot of folks looking for legal assistance are going on their mobile devices. And the way that people communicate with their friends and family when they have a legal issue come up are through different social media applications on their mobile phones. It's through different forms of communication on these devices when they're going and looking for help. So we have the LSC acknowledging that mobile is really the way that people are looking for this assistance. And if we want to create these tools and put them on there, that's great. But then we need to put the puzzle together. We need to find ways to engage with the consumers to get them to those tools so that they will be a great lead source. And I also, separately from the private sector, did a last fall international report on the delivery of online legal services. And I looked at law firms who are trying to unbundle and deliver services online, very similar to the way that some of these technologies we're talking about deliver access. And what I found from that report, just doing very small studies of different law firms, was that when they delivered unbundled services online, the consumer still dropped off if there wasn't some kind of engagement, more than just a call to action on the website, more than just using SEO, doing keywords on Google to pull them to the website. They would lose that lead. They had to have some way to nurture it to turn it into a paying client. I think the same thing happens in legal services, where the consumer has a legal need, but then they find this website, but then how do they engage? What do they do? There needs to be more walking them through, more hand-holding. And from the study I found, for example, Slater and Gordon in Australia is very successful. They have a separate website. They market for online legal services. It's estate planning and I think some small business assistance. And it's successful in part because they have a toll-free number at the top, because they found that people won't just click to go in and follow some kind of expert system or doc automation and assembly program to get their documents. They want a little bit of a human interaction. They want to hear a phone call with a human. Doesn't even have to be a lawyer saying, it's okay, thank you for choosing our firm. There are lawyers behind this website, and these are quality legal services. And then people will engage with the firm. They'll go online, they'll use those resources. So taking kind of what I learned from that study of private, bar law firms, and then applying it to what I see from the Legal Services Tech Summit report, I think that there are ways we can increase engagement to get people who have needs to get access. So there's some concepts I want to throw out there around games and why games are useful to increase engagement. Flow is one of these, and flow is a concept that an American psychologist called Csikszentmihalyi, that's how you pronounce it, he defined this, and it's this exhilarating feeling of creative accomplishment and heightened functioning. When you play a game, your brain actually releases a little bit of dopamine. It's a positive feeling, a good feeling, and what that does is that makes you much more receptive to learning, to engaging, to continuing on through that website or that expert system or that walkthrough. And then the other concept is fiero, which is an Italian word for pride. And when you play a game and you complete a level, or you get a little, some positive affirmation of some action you've taken, whether it's a swipe on your mobile phone that makes a little noise, like a swoosh or a ping, it creates this sense of pride, and that is also a neurochemical high. And you can create games to encourage people to learn things. So there's this whole genre called games for social good, and it's relatively new, but in other areas, they've been creating games that increase engagement and get people to use the technology to learn and to help themselves. And so there are a couple examples. This is the website for gamesforchange.org. And Half the Sky, I don't know if any of you have played this on Facebook or heard about it. There was a book written about it that went along with it. But the game itself is, and this is a screenshot of the game, you play with your friends, and you put yourselves in the shoes of a woman in a country where the resources are not as plentiful, and she has a daughter, and you have to walk through the game and make choices about where to spend your money, your limited resources. And so you're learning about being in the shoes of someone else. At the same time, you can also donate in these different interactions. For example, one of them is books, to and there are different nonprofit organizations that partnered with Half the Sky. So you can choose with the rewards you win to donate books to children in that country. And you can share all of this with your friends. So it's teaching, it's also letting people have fun and sharing on a social media platform. This is free rice, and a lot of people just do this first thing in the morning for fun. You go on and you just play, you click the right answer. Heat means you pick one, and every time you get a correct answer, it donates a grain of rice through the program. So for people who want their mindless, mobile phone gaming to have some value, there's an example like that. Data Dealer is another example we found that teaches about data privacy law and your rights. And it was created in, I think in Germany. But they have all the social connections through Facebook, through Twitter, and you go on, and I've played it, and you learn all these different data privacy rights as you're playing this fun game and you're sharing it. So those are all examples of the just different types of games for social good that are out there. So there are 2 games that are being developed right now for legal services that kind of along this line to experiment with, can this carry over into being some form of a solution to some access issues here. And one of those is with the Illinois Legal Aid Online. I've been working with Lisa Colpoys and Terry Ross there to create a game about eviction. And we're still developing it now, but the issue that came up was funding. So we came up with a game related to foreclosure. We got the funding through the Illinois Attorney General's office, started developing the game, and then she saw on her budget, the AG saw for the funding, that it said developing a game for legal services. And the word game in the legal services community, the funding was nixed completely. So we're halfway into the development of this game now. We switched it from foreclosure to eviction because now we're no longer under the restrictions of the AG's requirement that the funding go towards foreclosure related legal issues. But that game is something that, just using the word, we've come up against. It's not serious. But people play games and people learn from them. So we're carrying on, and Lisa's trying to find other sources of funding for us to develop this game. But here's some of the screenshots we have of the character. Now we're going to have the player play the landlord. This is to learn about eviction law. It's going to be a cross-platform game, so you'll be able to do it on your mobile device. So through Facebook, you could pull it up, you could play it, share. It will have sharing components with Twitter and Facebook, so when you complete a level or you win a reward, you can share that, and that will hopefully spread it around to other people. And what that will do is increase overall general knowledge about eviction law and rights. And it's going to be a top-down platform. If anyone plays Farmville, where you look down at a town, it's going to be a landlord who is controlling different properties. And so what happens when different issues come up, whether you can put the eviction notice up, whether you can continue to collect from that tenant, things like that, to teach the consumers their rights. And the second example is an estate game that I created just on my own. Been bootstrapping this. I put it up on Rocket Hub to try and get some funding and some interest around it. It's called Estate Quest. And I was an estate planning lawyer who delivered online unbundled services for 10 years. And one of the issues I always had when I put, through my virtual law office, put this out there is that people would get hung up on issues that they didn't understand, like guardianship. How do I choose a guardianship for my family? What is an executor? And just not knowing those legal terms. So how do I explain that in layman's terms to them? So I created this game, and it involves a time machine, and level 1 of the game is basically showing someone the consequence of not having estate planning, not naming a guardian. What could happen to your children? So in the game, the Archibald, the main character, it shows you he's gone to prison because his parent didn't name a guardian, and so he ends up with crazy Aunt Marge. And so through, again, seeing the consequence and what would have happened if the father, you go back in a time machine and you sign the will that names the guardian, which is his grandmother, and then you see, okay, we solved that issue, and through solving the issue, you learn about guardianships, why it's important to have that clause in a will. So that's just level 1. There are a lot of different, estate planning issues, but hopefully it would teach consumers basic estate planning concepts. And I think that you can do this with a number of other legal issues. So not just looking at engagement to help people find these tools that we create, some of the initiatives that, that Ron was talking about and the LSC Tech Summit talk about, but also looking at it in terms of preventive law. How can we use these tools to educate people to stop the problems before they happen? Because I think that's another key part of it. And the last thing I want to mention is the Blueprint Project, which Will Hornsby has really been the spearheader of this entire thing. And we met at Stanford about 3 weeks ago, and it's a project that's being hosted by the ABA Standing Committee on the Delivery of Legal Services. And what we're trying to do is ABA presidential funding, I think, for a year. And we're trying to look at this issue of access. Why do we have all these under and unemployed lawyers at the same time that we have this huge access gap? And how can we resolve this? So we're looking at pulling in a multidisciplinary team, which we did here at Stanford. The Center on the Legal Profession hosted it for us, and we had I think a brain scientist, a big data expert, a psychologist, a sociologist, people outside of the legal profession to look at this issue. And how then can we take their feedback and create some kind of online access hub? And so the end goal for us is to sort of remove the repetition and all these talks that are wonderful, but we keep seeing these same issues come up. Harvard had a symposium on access. Stanford has a symposium on access. The Tech Summit report. All of these wonderful technology ideas to increase access, but they're repeated over and over. So the idea is, let's see if we can't use design methodology, and we're working with Margaret Hagan and Ron Dolan's their program to use design methodology to figure out what would be the most useful way for us to take all these access ideas and failures, so the ones that haven't worked in the past so we don't keep repeating it, put them in an online place, and then say, okay, legal tech startups, entrepreneurs who want to take some ideas and run with them, here are some ideas, here are some solutions, and really back it up. So that's all I have. Forward looking, yeah.
Great, and that's the perfect segue. Let me just note, we're going to go till 3:45, so we have a 1 hour for the session. So Stephanie teed up very nicely this notion of design thinking and the use of design concepts in legal innovation that Margaret would have talked about if she were here, that she and Ron have been doing a lot of at the D School this year. I'm going to take just like 3 minutes to give you a flavor of what that looks like without any of the details, and then we'll move on. So basically what Margaret and Ron and others are up to at the D School is essentially designing a system or an approach to legal innovation. Out of that, some specific, new products, new services, new things will come. But the meta picture of it is, let's sort of refine a system for using design concepts to actually go about legal innovation. And it's very much a design-driven, user-centered approach to trying to figure out how we research and how we design new innovations. It's very hands-on, very interdisciplinary, as Stephanie was just describing in terms of the workshops that they do. But I think it's really important to note, this is a really exciting and in some ways novel new approach to things, and yet it's not. There's nothing new about this, and Ron was just describing how in the early days of creating A to J Author, these principles are exactly what they use. Very customer focused, very much about getting out in the field, understanding what the users, the consumers, the people who would do this actually needed and how they would use it. So it's sort of generation 2, generation 3 maybe of using these principles, trying to refine them, but it's not anything new at all. So guiding principles, very participatory. You've got the stakeholders, whether they're lawyers, clients, legal aid providers, computer scientists, psychologists, whoever, all involved and working in interdisciplinary teams. And it's done very quickly. It's very iterative. There's a lot of ideas that are prototyped, tested with users. Failures are discarded, promising things are exploited and moved on. So it's very quick and iterative. I'll skip over some of the process, but the basic steps: generate really cool ideas leading to a prototype, then you pilot them quickly, Get them out there, try them, see what works, experiment, test, and improve. And then once you've got something that works and it's actually fairly solid, then you scale it and you spread it across to people who are going to use it. A few of the specific things they've done this with this year to sort of develop this process. One was a series on making immigration user-friendly. So basically building tools for college students who are not US citizens to understand their immigration status and rights and possibilities and so on. Again, very interdisciplinary team, brought a lot of people together to figure out how to do this. Another one's focused on estate planning, redesigning the estate planning process. One focused on criminal justice and plea agreements. Another on legal notices, sorts of things that we all see and completely ignore because they're completely inaccessible on a day-to-day basis. And this is the process, right? Just to click through what they do. Lots of interviewing of the people who are involved, users, attorneys. Then you take those notes, sort of try to get them all out into something you can work with, brainstorm through that. And then part of what makes this so cool is the team then tries to work to help quickly develop what the best ideas are and to percolate those up higher and to leave behind the things that aren't particularly useful, and then turn that into a prototype, turn that into a starting point that you can then test and pilot and play around with. Develop early prototypes, present those to the group, and test those with your audience to see sort of how they work. Is this good? What's gonna succeed here? Where are we gonna run into problems? And so on. And then presenting the final design kind of. These are often called sprints. They're sort of like the design version of hackathons. These happen very quickly in a compressed time, and you go from 0 to a pretty advanced stage very quickly. So these are all concepts and an approach to design that can apply to so much of what Ron talked about and what we've been talking about. Sort of how to reduce the failures, how to make the efforts to innovate and sort of think about new ways to come at some of these problems more successful, more quickly suited to what the actual users are going to need. We can build some beautiful systems and some things that designers or computer science folks or even lawyers think are perfect. And if you put them out there and the consumers, the unrepresented people who use them, come to them and go, what do I do with this? I lose interest partway through. I don't know what a conservator is. Whatever. It's not going to work. So these are tools designed to try to bridge that gap, move us more quickly toward tools and services and innovations that actually work and actually solve the needs instead of just look really cool and shiny, but then don't quite do what we want them to. This is a process and an approach that many of you, at least around Stanford, are quite familiar with, but it's one that hasn't been used, other than a lot of Ron's early work, hasn't been used regularly and consistently in a lot of the access to justice efforts. And it's one that in theory could make a huge, huge difference. So I'm going to stop with that. I have one question for these guys that's especially interesting for me, and then I want to open it up for all of you for questions as well. And the question I have, given this crowd particularly, is sort of talk a little about the intersection or the space of this kind of access to justice work, which, as you've described it, Ron, is mostly law schools have funded it. Legal Services Corporation has some money now, but it's this limited pool of money. But at the same time, you talked about this great possibility of revenue streams now from lead generation and things like that. Suddenly, this is something that's potentially attractive to entrepreneurs and others. How do these two worlds come together? What do you see as the possibilities that entrepreneurs and people looking to do commercial things can actually contribute to the access part, rather than these being kind of two separate things that don't ever meet?
Well, so my sense is that this gathering is by far the most advanced effort to do what you just said. The circles move in different spheres. I mean, they're just slices of different worlds. And I mean, I'll give you an old anecdote. Maybe some of the Will might remember this. So when Illinois Legal Aid Online was just getting started, it was incubating at Chicago Kent Law School. And a man, and they had people there that ran a countywide hotline to help people find the right legal aid organization. And we're building this statewide website. And it was expensive. It was literally millions of dollars to build this really state-of-the-art web portal. And a man came to the meeting, and I can still see his face, and I know his name. I won't tell you what his name is. And said that he had a company that had a call center, and he would build the website, pay for all the software and the design and construct the website. That he would, in addition to providing that resource and hosting it, that he would also provide a call center backup so that the countywide call center could be blended into that, and he'd handle all the calls and staff all that, and he'd do all that free. Right? All he wanted was the lead stream, the people that didn't qualify. He was going to take that and exploit that lead stream, and they froze him right out. They didn't. Nobody even gave him. One person, the head IOLTA, was really excited about this. She brought this guy in. He made his pitch. She kept bringing him back. Legal aid people would have nothing to do with him, right? And I think I think there's a little bit of cultural aversion to profit when you're a legal aid lawyer with your whole life. You know, you've spent your entire life sort of sacrificing your opportunity to make $1.5 million a year or whatever it is, and you know you're and you have a certain sense of moral purity from that or something. And I think all of them were afraid that somehow the people coming to the site would be exploited, or they wouldn't, because they lose control of the lead stream as a group of people that were looking for help. So that's an anecdote to me that rings true in lots of other settings where I've seen these two groups come together. I think this is a very hard problem to try to get these two cultures to blend. And I really commend Stanford and you guys for pulling this together, because you did a little bit today. It was really nice.
Stephanie, as somebody who's been kind of close to this divide on both sides, you have thoughts on this
Yes,
issue?
I think that law schools should teach practitioners more about limited scope representation and unbundling, and get lawyers used to the idea of how to unbundle, and also the idea of serving low bono clients. So if we could learn to collaborate with some of these branded networks to deliver online unbundled services for lower fees, I think at the same time we would end up getting recurring clients, full service clients that would come from that as practitioners. And I think that collaboration would also be a way that those companies could potentially match people that come in that qualify for legal aid services to the appropriate legal aid service if they qualify. But a lot of them don't qualify. They could pay something, just not a lot. They could be low bono. So I think just practitioners being open to unbundling low bono, and maybe more just collaboration and maybe some relaxing of the advertising rules and our ability to collaborate with branded networks would also really facilitate that happening.
So one other comment, Phil. I mean, so if there is maybe a little sliver of hope, it seems to me it's the incubator movement, right? Because it's coming out of this. There's all this need, and there's all this extra resource. These people can't get jobs, and the incubators are being supported by law schools and sometimes by legal aid organizations or the trust funds in various places. And there's some effort to say, well, all right, you're going to get this incubator environment, and maybe what you pay for that is 10 hours a week helping out with legal aid or whatever it is. And so it's sort of bridging those two gaps, or those two worlds. And the key problem in surviving and making your practice launch successfully in the incubator setting, in addition to mentorship and skills, is client streams. You need access to clients, and so this is right in that space.
Yeah. Questions? Yes, sir.
Lead guy. Oh, sorry. Yeah. Well, and just as a response to that, I mean, the legal education world is pretty conservative too about this stuff, and so Richard Granite with the direct law has made a similar offer for years. We've gone to tech shows and said we'll give you this backbone. That's a wonderful offer that you made. It's a valuable asset, but it's still hard to get people to accept this free thing, right, and use it.
Go figure. Yes.
Kind of support at the beginning, yeah.
Yes, sir.
There we go. So 2 points. I appreciate that you both devoted time to focusing on this area of the law because I think it's hugely important. And at the same time, I have to admit I have kind of a visceral negative reaction in some respect to both presentations, and I'll try to explain why, because I think, and I hope you take it as constructive. I want it to be taken as constructive feedback because this has a lot of real deep personal importance to me. So first of all, I don't think there are any judges in this room. Correct me if I'm wrong. Is there anybody here from a court? Courts? One? Okay, not a judge. No judges here. I think a lot of the problems in pro bono representation and people who are frankly just too poor to afford legal services stem from court processes. And I didn't see anything in either presentation that addresses what's going on in the courts. Everything stops short of that. And that is the core problem. So to the extent that this is essentially a Band-Aid on a huge gaping wound, it doesn't even cover the wound. So that's my first point. Second point is that I have a brother with autism. And to prevent him from being effectively kidnapped by our county mental retardation and developmental disabilities board, which just sent us letters saying they were going to take him away because they felt like it, it cost my family a huge amount of money to keep him out of their clutches. We didn't want to play a game. We didn't even want to consider the notion of educating ourselves about the probate court's process. We just wanted to keep him from getting killed by a government that had no interest in what we thought. So the notion that games are being funded, it strikes me as a little bit off when the real problem is what's going on in government. And I don't think games are going to solve that. Thanks.
I'll respond to the game part. So that's the preventive law, and it doesn't work for all legal issues, and it's just one component of an access issue. Definitely, it's not appropriate.
Yeah, let's be sure to get one more.
Can I just respond? You can't prevent people with mental illness from having legal issues. A lot of the poor people who can't afford legal services have mental illness.
So what I was talking about, my examples were estate transactions-based issues like estate planning, just teaching basic laws and rights. So Sandra Day O'Connor, for example, did a whole group of games that are civics related to teach people about the basic judicial process and civics. So this is an extension into different substantive law games that educate people on basic rights. Down the line, there would be other resources. So if they have an eviction notice stuck on their door, they play this game. They played it, let's say a friend told them about it a couple months ago. They've played it. They know where to go now. It pushes them to the resource where they can create the documents they need to take to the court to fight it. So it's just a preventive law component.
Right, one quick last question.
Good. My question is about, so my relationship with pro bono work is volunteering occasionally at a legal aid clinic in San Mateo County where they basically help very, very distressed people who need temporary restraining orders. So it's a domestic violence clinic, and I volunteer there sometimes. And the people that are entering that clinic, just most of them are native Spanish speakers who don't speak English, and they have very acute needs but they don't use Google. They don't use mobile apps. They don't use anything. So but they do have these huge needs. So my question is, how is technology being used to address the needs of the people that are not even they're just outside of this whole technological, I don't know what you call it. They're not using media the way a lot of people in this room are.
So basically I have two reactions to that. One is that there's all kinds of technology that, including hot docs and some of the tools we talked about here, that's being used to support people like you. So maybe you're a tax lawyer and you go to this clinic involving domestic violence and you don't know the first thing about domestic violence, but you can be guided through the right kind of interview and make sure you get the right kinds of forms, because you can go fast through these things, and that can support you to make sure that the relief that you provide in helping somebody like that is effective, right? So that's one thing. The other concept here, and to some extent a little bit responding to the earlier question, I mean, there's this huge sort of pyramid of need, and if you say we're going to cover all the need with this pyramid, the bottom layer maybe can be self-help and education and web stuff and games or whatever it is, and then the next layer is live chat and phone calls, and you work up, and at the top you have full service by an excellent lawyer who's worked in the field for 10 years and really knows what they're doing. And the question is how you get the right resource to the right person, and to make sure that you have enough resource in each one of those layers of the pyramid.
I think you're right. A lot of the people that learn about this clinic don't even learn about it through a phone call. They learn about it just through word of mouth, which is often from like a police officer who's doing the arrest or whatever. So,
good point.
All right, we have to stop there, but join me in thanking our panelists.